Hello, everybody. My name is Dr. Will Bateman. I'm the Associate Dean of Research at the ANU College of Law, and welcome to today's presentation event towards the environmental minimum, a book talk by Dr. Stefan Theil of the University of Cambridge with the discussant, Dr. Emma Aisbett of the ANU. I'd like to begin by acknowledging the traditional owners of the land upon which I am sitting while I meet with you today, the Ngunnawal and Ngambri people, and I would like to pay my respects to their elders, past and present, and extend that acknowledgement of country to the traditional owners of the lands from which you may be zooming in on today. We're very lucky today. This is an amazing opportunity to hear world-class scholars in discussion on topics of particularly great moment. We have our main speaker, Dr. Stefan Theil, who is Assistant Professor at the University of Cambridge, and John Thornley Fellow of Sydney Sussex College, also at the University of Cambridge. Dr. Theil holds a PhD from Cambridge and a Masters of Law from University College London, and before joining Cambridge as a permanent member of staff, was a postdoctoral fellow in human rights and the environment at Oxford University. Dr. Theil is a widely published expert in environmental law and human rights, with an interdisciplinary flavour, particularly the importance. His work emphasises particularly the importance of bringing empirical methods into legal and doctrinal studies of human rights, the environment, and public law, which creates a particular synergy with our discussant today, Dr. Emma Aisbett, who is Associate Professor at the ANU School of Law and the Associate Director of Research for the Zero Carbon Energy for the Asia Pacific Interdisciplinary Grand Challenge project, which is headquartered at the ANU. Emma has degrees in chemical engineering from UNSW, Australia, environmental management from the University of Oxford, and a PhD in economics from UC Berkeley. Emma is one of our most interdisciplinary staff members at the College of Law. Dr. Aisbett combines her interdisciplinary understandings of law, climate science, and engineering and economics with extensive government and industry engagement to develop solutions to problems at the intersection of international economic regulation and the environment. Dr. Aisbett is one of the world's leading interdisciplinary scholars on climate policy and international investment agreements, with over 600 citations to publications in leading law, political science, and economics journals. In addition to those pure scholarly achievements, Emma also provides advice to the Australian government and industry and to international organisations such as the World Bank, the Asia Development Bank, the OECD, and the UNCTAD. Now, those are the speakers to the book. Dr. Towards the Environmental Minimum argues for the recognition of a comprehensive framework that addresses the relationship between human rights and environmental harm. The argument, and I've been lucky enough to read the book myself, is based on a unique and comprehensive data set of the case law of the European Court of Human Rights. And it is a rich and searching examination of the complex intersections of climate, environment, and the dignity norms which underlie human rights frameworks. This is a webinar, so please put any of your questions in the chat. You can see us, but we can't see you. So if you have things you would like to add or any ideas that pop into your mind, please do enter them into the Q&A function, and we'll get to them hopefully at the end of the formal proceedings. In terms of the order of events today, Dr. Theil will introduce the book for around 20 to 25 minutes. Dr. Aisbett and Dr. Theil will then engage in a discussion of scholars from across the world and across disciplines for around 10, 15, who knows, 20 minutes, who knows, several hours. We hope to finish relatively promptly at 5 p.m. And then as part of that discussion, we hope to integrate any questions that you may pop into the Q&A into the discussion. Now, I believe I've used the full chair's prerogative to speak for 5 minutes, and I'll now hand over to Dr. Theil for his book.
Thank you so much, Will. Thank you so much, Emma. And thank you so much, ANU College of Law, for having me here. And I want to also expressly associate myself with the comments and the introduction that Will gave earlier with respect to the traditional owners of the land that we are now operating from, at least in part and at least virtually. Greetings from Cambridge. It is quite early in the morning, so I hope you'll excuse the gaming headset that I put on. I'm trying to keep the noise down somewhat for my partner, who was should just about be getting up at this point, but doesn't want to hear me yap about my book again. So bear with me on this one. So thank you so much for that generous introduction. Essentially, what I want to do here is give you a bit of a flavor of what the book's about, hit on some of the most important themes, but obviously I won't be able to present it comprehensively. I hope that the session and me talking about it will give you enough of a taste for it that you might find it interesting enough to pick it out from the library and take a look and flip through it. But essentially, what my mission here is to address a how should I put this, a disconnect that I've seen and that I wanted to make sense of in terms of legal studies, but as Will has pointed out, hopefully in a way that engages and talks to other disciplines and does not just limit itself to the strictly law and political science remits that traditionally encompasses these types of books. So pervasive environmental harm disproportionately impacts vulnerable members of society, and yet it seems to be left largely unregulated in most modern regulatory states, to the extent that legal commitments to human rights and environmental protection in many states don't really seem to carry through into any real practical solutions. Now, partially this is because the phenomenon is only more recently been recognized as something that is worthy of intense regulation, but partially that is also because it is quite easy to change higher level norms like human rights law, like constitutional law, like other things. It is much more difficult to actually make sure that these things, that these changes at the higher level follow through in what I would call the micro level. So the everyday regulatory decisions about planning permissions, about polluting industries, about how to balance overall economic development with sustainability and environmental protection, all these questions, it is really hard for these higher level principles to kind of seep through and make sense in a more micro context. So what I try to do in the book is to kind of bridge that gap. I try to come up with a framework that allows us to translate these higher order commitments that we may have made in constitutions or in international human rights protection regimes, or just in the fundamental rights context as such, into something that actually makes a difference on the ground. That was the objective. Whether I succeed in setting that out, that I think I will leave for everyone who reads the book to judge. But at the very least, I hope that this is an attempt that allows us to fail a bit better in the future if it indeed did not quite follow through, or not quite deliver on its promises. So I start off the book by identifying a subcategory of human rights that I think necessitate protection from environmental harm. Now, I think that follows quite neatly from any sort of commitment to human rights. So there's nothing in particular that needs to be enacted from my perspective. It's provided that a state is subject to certain human rights protection regimes, whether domestic or international. I think there's a fairly straightforward argument of saying that any meaningful commitment to human dignity, to autonomy, even on some utilitarian arguments for human rights, I would say it's very, I think, quite straightforward to derive environmental protection from those. And that's mostly because I think, as Australians possibly better than a lot of other people might be able to appreciate, pervasive environmental harm threatens any meaningful enjoyment of any rights. There's not much use for a right to property when a wildfire is burning down your house. There's not much point to a right to protest if my area is flooded and the only way I can move about is in a rubber dinghy. So in the end, we have certain fundamental commitments underlying human rights, and these are fundamentally threatened by serious environmental degradation and harm. And if we don't come to grips with them, then all of these other commitments in some ways don't matter, or they won't matter in quite the same way. So what I want to focus on in the next couple of minutes is just to give you a flavor of the framework that I have developed that hopefully starts to make sense of some of these commitments and how we can make sense of environmental harm and degradation in the context of a human rights regime. So the first thing I suggest that we need is a specific risk. So we need to identify a specific risk for a human right. Now, a specific risk exists when there's a reasonable hypothesis based on scientific evidence that links an environmental harm that's out there in the world towards a threat to a specific and established human right. Now, that doesn't mean that there is a necessary causal connection here. I'm not proposing a standard of saying only if you can demonstrate beyond all reasonable doubt or to whatever evidentiary satisfaction of a court will there be a specific risk to human right. So, for instance, there's no need, in my view, in the context of climate change, for instance, to prove that but for an emitting industry having operated, let's say a coal-fired power plant, the glacier would not have melted. There's no need, in my view, for us to be able to say that. There's no need for that level of certainty. And incidentally, I think a state's commitment to meaningful environmental protection and perhaps even meaningful action on climate change, I think, can be judged quite well by their willingness to tweak some of these fundamental rules of law that operate across entire sectors and entire industries. So to put it bluntly, I find it a lot more interesting when a state, through legislation or through the development of the common law or through judge-made law or whatever it happens to be, is willing to tweak a fundamental accountability and liability mechanism, for instance, in tort law. I think that's a lot more interesting than putting a very high-level commitment to, let's say, legal personhood of a river or a mountain or a stream into their constitution. I find that is a lot more meaningful and a lot better indicator of real meaningful commitment to environmental protection. So we need the specific risk, but why do I insist on the specific risk at all? Well, because I think and this is another big theme of the book, I think we need to operate within established categories and mechanisms of the legal system. Now, I'm a bit of an outlier with this, I'll admit. Most people who write in this field think we need a radical rethink of how environmental law and how environmental regulation operates, because in their view, and not without some justification, they're saying, well, we haven't actually been able to tackle some of the most meaningful and detrimental environmental challenges of our time, first and foremost, climate change. So what we need is a radical rethink, these people say. I disagree. I think ultimately what we need to do is we need to make the categories and we need to make the legal principles, the systems and the regulations that we already have work. And I think we can make them work. So a specific risk is necessary to tie us back to whatever existing environmental human rights protection regime we have, whether that's domestic, whether that's international, or whether that's even operating at the very local and regional level. So essentially, the specific risk ties us back, and a good example of that is, for instance, the use of a very well-known herbicide called glyphosate and its connection to developing cancers in humans. Now, the causation is by no means all thought out. It's by no means clear that there is a causal link there, but it's enough of a specific risk supported by a sufficient body of credible evidence to at least open us up into this category. The specific risk is the trigger that leads us into the examination that I'm interested in. An example where this is not established, I think, is fluoridation of drinking water, where there is just no scientific basis for saying that there's any tangible detriment to humans. So that would be one of those things that doesn't quite meet that threshold. Now, once we've met the threshold, we're in the specific risk category. We move on to the meat of the matter, which is the minimum standards. So what does a state that has a commitment to human rights, what does it have to do in order to live up to its environmental commitments under these human rights protection regimes? So I think there we operate on the basis of three standards. And broadly speaking, they're the established legal standards, they're the legal standards, the established standards, and the emerging standards. So with the legal standards, it's quite straightforward. These are all of the domestic and international legal obligations that a state has taken on, the commitments it has made in law to provide environmental protection and an environment of a certain quality to its citizens. So I think that is the one that's the most straightforward for a court to apply. It's a very simple yes or no. Are you complying with that legal standard or no? And that's a very comfortable place for courts typically to apply that sort of standard. The more important category, I think, is when we don't have such a legal standard in place, either because the state has not committed itself to any particular objective or because there indeed is no objective out there yet. There's no scientific there's no political consensus around a particular objective that's supposed to be met. So we might take it as an example, the pre-Paris climate change agreement days in terms of climate change. So everyone was in a general agreement that harm reduction should be accomplished, but no one had any particular objective in mind for the world community to meet. Now, in those circumstances, we fall back on what is the best scientific evidence that is available to us at the time. So experts in international organizations, just the WHO, they routinely weigh up and conduct meta surveys of what's going on and what best practices are with respect to certain environmental harms. And those, in the absence of legal standards, form the objectives that the state should be attempting to meet in the absence of any particular legal standard. So in other words, a court or any other decision-making body that is operating under the framework I'm proposing is supposed to push the state towards achieving these objectives, in the sense that if the state does not commit itself willingly, voluntarily to a particular standard, then we will fall back on what is the consensus or the near consensus in a scientific community on a particular question. Now, I don't want to overstretch the word consensus here. There's always going to be detractors. I'm sure that if you poll 100 climate scientists or 100 people who operate in the sciences, broadly speaking, there was always going to be one or two people who may even to this day still deny the reality of climate change. That does not necessarily mean that there isn't a consensus or that there isn't a overwhelming majority in favor of a particular scientific view on climate change. So I don't want to overstretch that there's never going to be 100% consensus, and nor does there need to be in order for us to act. So we don't need complete certainty to act on certain insights that science is telling us and has confirmed over and over again. And finally, the last and arguably the most loose of the standards that can be applied is in the absence of this level of scientific coagulation, this level of scientific consensus around a particular view. So if there are persistent uncertainties, if the scientific mechanisms are just not well understood, or if there just isn't a clear consensus on any particular on the particular question in the relevant scientific community, then what we have is essentially an emerging standard. So that doesn't put any hard and fast rules on a state. That essentially just gives it a certain direction of travel, but ultimately it is then up to the democratic process, the legislation, and the weighing up of competing interests to determine whether and what action should be taken. So that's probably the loosest of all standards that would be applied under this principle. Now, just by way of sort of clarifying and introducing some elements of the book, I just want to kind of distinguish it from some other principles that might be out there that you might have heard of. So some of you, as I was talking, maybe were thinking about, well, how does this relate to the precautionary principle? We already seem to have a principle out there in international and some domestic legal system that tells us what we should do in situations of uncertainty, how we should behave in a regulatory sense. Now, I think that there is something to that. The framework that I'm proposing has some conceptual similarity with the precautionary principle. But overall, I think the precautionary principle itself is quite rightly being criticized in a lot of the literature for making quite simplistic and unobjectionable statements on the one end of the spectrum, and on the other end of the spectrum, making partially incoherent normative claims that don't really help anyone who's trying to make a decision in a regulatory context. And let me explain why I think that is. So if we're going to adopt a very weak form of the precautionary principle, it might go something like this. It might say, not having sufficient information about the effects of a potentially environmentally harmful conduct shouldn't prevent you from regulating it. So just because you don't fully understand by what mechanism, for instance, a harmful industry is going to damage the environment, doesn't necessarily mean that that needs to stop you from imposing certain restrictions and regulations on it. Now, that's true, but it's also, and this is the problem, I think it is also a truism. Of course, not having complete knowledge of something shouldn't stop you from regulating, but by the same token, not having complete knowledge of something also doesn't mean that you necessarily do have to regulate. So it gives you a reason not to eschew action, but on the other end on the other hand, it doesn't give you a strong reason for action either. You are still left in the same position as you were before. You are still ultimately balancing things that you don't quite understand. And in that sense, the precautionary principle in this weak sense doesn't really help you. So that's a bit of a problem, I think. On the other end of the spectrum, if you took a very strong claim, then we might say, okay, the precautionary principle might say something along the lines of, okay, cool. So you have this potentially environmental harmful conduct, and unless you can prove to the satisfaction of an expert panel in a court that the conduct that you want to engage in is not environmentally harmful, then you don't get to do it. The problem is that that has the danger. I think that's the more interesting version of the precautionary principle that also carries within the danger that it needs to be quite specific, because you need to tell us what it actually is that we're supposed to be precautionary against. So let's take a very simple example from agriculture. So when you decide whether or not a company should be able to use glyphosate, the possibly carcinogenic herbicide that I mentioned earlier, you might want to weigh up things like food security with public health. Okay, but unless the precautionary principle tells you what risk you're supposed to be precautionary about, are you supposed to be careful with food security, or are you supposed to be careful with public health, or both? If it's food security, or if it is public health, if it is either one or the other, then you can optimize for one or the other, and that's fine. But if it is about both, if it's a general principle that you're applying across the board, then you're back to where you started, because effectively you don't know how these two things are going to relate to each other. You're back to balancing them too, and the precautionary principle hasn't really added anything of much value to your regulatory decision. So I think those are some of the reasons that the precautionary principle isn't as useful as I think the framework that I'm putting forward is going to be. And the last, and I think final objection or possible objection that I want to deal with before I turn it over is polycentricity. Now, you don't necessarily, probably you've never come across this problem, this issue before, but polycentricity is a concept that was developed by Lon Fuller, an American legal scholar in the 60s, who came up with this idea. So essentially, it means that whenever you're making a regulatory decision, you have a lot of possibilities for unintended consequences. So if you imagine making a decision about, let's imagine you're Tesla, and you're trying to figure out at what price point you want to sell your latest model. There's a lot of factors that go into that question. So on the one hand, you have your production costs. On the other hand, you have your labor costs. Then you have to take into account whether or not you want this to be a mass marketed car. So do you want a lot of people to buy it? Then that speaks for a lower price. On the other hand, you might think, well, we want to be a premium brand, so you want to sell it for, but you don't want to sell it at too low of a price. Then you have to take into account the overall economic outlook and development. Will people be able to afford this in the numbers that I want them to buy it? What's my marketing budget? And all of these things don't just influence the way that you might want to set your price, but they also ultimately come back and influence some of the factors that ultimately that informed the price decision in the first place. So to make a very simplistic example, if you take labor costs, and if you take labor costs, for instance, you might say, okay, so if I price this at a lower point, then I can sell more of them, and potentially I can settle a union dispute that I'm currently having I can settle it earlier, and I can therefore be able to sell and produce more cars in a shorter time period. And depending on that settlement you reach with the union, some of your workers might be your customers, because again, the price point that you're setting. This all sounds a bit complex and abstract, but the point here is just that you cannot take decisions in isolation, and any decision that you take will reverberate throughout a complicated system and come back to influencing the very factors that form the basis of your decision. Now, that's an observation I think that is just generally true about the world, because it's an interconnected world. However hard we might try to isolate ourselves from each other, we can't. Practically speaking, we're a social species. We interact in very complicated and nuanced ways. And that means that anyone's decision, even if it seems entirely trivial and inconsequential, reverberates through a complicated system, it might actually produce some very strange consequences down the line. I think that's just a generally true observation about the world that we live in. The conclusion that Lon Fuller draws from this observation, however, is that courts are not a good place to deal with complicated systems. He said courts aren't good at this because ultimately it's always a bipolar decision for a court. Either the court rules in favor of the person who's making the claim, or they rule in favor of the person whom the claim is made against. There's no in between. There's no negotiation in that sense. They can't, or they can only to a very limited extent, balance the interests against each other. And therefore, says Lon Fuller, these complicated systems need to be dealt with by markets. And by markets, he doesn't just mean the marketplace of offer and acceptance and of supply and demand. He also means legislatures, political processes, because he thinks there's scope there, there's possibilities for these backroom deals, for horse trading, for things that you just can't do in a courtroom. Now, I think to a point, there's actually something to that, but the core rejoinder, I think, to Fuller is Fuller himself, because his recognition of polycentricity, this idea that you can't actually ever make any decision in isolation and you don't understand this complicated system, surely that applies to all modes of human decision making, whether we deal with it in a legislative context or in a judicial context or in a market-based context. We are always falling prey to these pathologies that Fuller has recognized and I think quite rightly identified. So what I'm missing here from him, or what I would have liked to heard more about if I ever had the chance, would be something along the lines of, why is it that courts are particularly affected by this? Because surely there are different forms of courts that operate in the world. If his statements were true, then probably only on a very narrow account of what courts are actually doing, and there are different types of courts out there that do different things in different ways. So how is it that courts are particularly affected? But I think the strongest rejoinder possibly is that it is really difficult for Fuller to take account of decisions where we reach arguably quite morally sound outcomes. So, for instance, we could take Brown versus Board of Education, ostensibly only dealing with the admission of a particular group of children to a particular school, but obviously in its consequences and in what it was saying about the US Constitution, quite far-reaching consequences ultimately. On Fuller's account, that was a bad decision to take, because ultimately it was a court making a very bipolar decision in a very complicated system that reverberated in very unexpected ways. True, but also undoubtedly the right outcome, because all of the mechanisms that Fuller identified, the legislature, market-based mechanisms, they had abjectly failed to produce a morally acceptable outcome in Brown. So Fuller has difficulty accounting for these types of cases where the market just simply runs out. And more generally, I would say market-based mechanisms tend to operate quite poorly, and this is where we get back to environmental law, quite poorly in situations where grave imbalances of power persist. So if you have a grave imbalance between the interests of industries, polluting industries on the one hand, and whoever it is who is speaking up for the environmental interests, possibly even those interests of future generations, then market-based mechanisms, horse trading, if you will, legislative processes tend to work quite poorly. Finally, before I close, just the last word on why I did ultimately focus on the European Convention, quite a lot of my attention in the book. That's for a very simple reason, because there are over 300 or so judgments in the European Court of Human Rights already on environmental issues. And that allowed me to dig quite deep into a reasonably big data set, at least by the standards of law. I once talked to a friend of mine who does experimental psychology about the quote unquote advanced empirical methods that I was developing and trying to apply in my book. And he thought that was quite quaint, because that's all stuff that he did in his first year of undergraduate studies. So I think it's fair to say law has a bit of a way to go. That is one of my pet peeves, trying to infuse doctrinal reasoning, so the way that we talk and develop principles on the basis of what judges and courts have said more systematically, in a way to avoid the big cases and avoid the overly strong focus on the big cases and focus more on what courts have been doing in the round. And I think one way, an essential way of coming into grips with that is to actually knowing what they've decided and to be able to talk about a whole lot of cases, hundreds, maybe even thousands of cases, without actually talking about them each individually. And I think that's the promise of a bit of a turn towards data and doctrine. But I'll leave that here for now, I think, and hand back to Will. Thank you so much.
Thank you, Stefan. Very provocative, very interesting. I've got 1,000 questions that I want to ask, but I can't ask them yet. I'm not allowed to. I will hand over to Emma now for a discussion, and if it pops up, I might jump in with a few of the things that have been prompted in my mind. So Emma, over to you.
Thanks, Will, and thanks, Stefan, for the introduction and for all the effort that's gone into this book, both conceptually and empirically. A very impressive feat. So it's a pleasure to be here discussing it today. I think I'm trying to take away, what is the most simplest way of understanding what you're really urging for. And there's a couple of different angles I'd like to take. One thing that seems to jump out at me is this really urging the system to make use of experts and of scientific consensus, and acknowledging that those other mechanisms that you refer to, market and political mechanisms, don't always do that very well. And indeed, in recent years, the political ones have been doing that less and less well, as we've seen, quite an outright rejection of expertise as informing policy. Do you think that's a fair assessment of one of the lines of which you're trying to innovate?
Yeah, definitely. So I think my biggest concern with the way that it's framed in a lot of the legal literature anyway, I think there's a lot more sensible things being said on the environmental side of the literature. But in the legal literature, a lot of the focus is on, we need to tear this down and we need to start fresh. My big concern is that we just don't have the time for that realistically, especially when it comes to climate change. And I think conceptually, obviously, the appeal of a blank slate is marvelous. But I think if critical theory has taught us nothing else, then it's definitely that no one starts with a blank slate ever anywhere, and we need to make the best use of the things that we already have. That doesn't mean that we can't radically change things. It doesn't mean that change isn't possible or desirable. But and this is probably the small c conservative in me, I have a strong preference for incremental changes on the basis of established legal principles that I can work with, that I can predict. If there's a legal revolution or a revolution of any descriptor, then I think a lot of the bets are off, and I'm not always convinced that it's going to go in a direction where necessarily is an improvement on what we had before. So I think there's a bit of maybe this is the British influence, a bit of a Burkean reluctance to change too quickly, too fast. But in answer to the second part of your question, I think, yes, it is an appeal to turn towards expertise, but not for its own sake. I think there's a very strong, I think, and rightfully so, a strong delineation between informing policy and quote unquote making the decisions, and making the actual policy decisions. So I think, it seems weird to say it in this way, but I'm a Democrat. I believe in the democratic process, and in that it should be the guiding light as to how we make decisions in society. And that means that in principle, at least, I also need to bite the bullet and say, yes, in principle, you can also democratically take decisions that are scientifically illiterate. That's true, but that doesn't mean I can't infuse the legal process and the policy process with as much expertise as possible, so that at least when we take these decisions, we know that we took them, and we knew with a reasonable certainty where they were going to take us. So yeah, that doesn't take anything. All of this is just to say that science is not a replacement for activism. We need activism and we need science. So being a poor activist, I like to focus on how we can infuse the political process and the legal process with the science, but it still needs people to actually want things to change. If that's not a given, then yeah, we're not going to get this by government fiat. We need people to actually buy into it, or at least a critical mass of people to buy into it. So in that sense, conservative, but hoping that there are more radical elements out there who want to help us out.
So I think that it's very clear that you're not trying to say that the courts should usurp the democratic process. If I understand you correctly, that's the whole positioning of, the word minimum in the title and the human rights framing is, let's let democracy and markets and everything else do what they can in terms of optimizing, but this has to be a constrained optimization. Sorry, you can tell I'm an economist. And at some point there is a minimum beyond which the courts do need to step in and stop total collapse or violation of these minimum standards or violation of human rights. Is that a fair summary?
Yeah, no, I think that's right. So that's the institutional role that I see for courts. Obviously that applies only with caveats to a lot of jurisdictions, because some jurisdictions, I think especially Australia, but I won't lean too far out of the window when I say this, it takes a bit of a more restrained view when it comes to courts interfering in the political process. But indeed, I think the proper role of a court, and I won't get into the details as to why I think that, but I think the proper role for a court is indeed to put in certain guide rails, to say that the democratic process needs to take its course, and it needs to be in the driving seat, so to speak, but it needs to operate within certain guidelines. There are certain things that are just not, that should just be taken off the table. So it's more, instead of the courts saying this is what you should do, courts should mostly be in the business of saying you can do many things, but you can't do that. So translated to the environmental context that we're operating here is, you can do many things in terms of environmental regulation and policy. You can have different thresholds for pollutants in the air. You can decide that you want higher or lower thresholds for cyanide in drinking water, but you cannot prescribe a level of you cannot accept a level of cyanide in drinking water that is in the short or longer term proven to be harmful to humans. If you're prescribing a level of cyanide in drinking water that is deadly or that will kill someone within a couple of years or months, that's not an option you're allowed to take. Whether you then go for the more ambitious thresholds that maybe some progressive scientists are suggesting is the right one, or whether you're going with the established one, that is less of a concern to the framework that I'm putting forward. There might be good arguments to go one way or the other that I don't want to preempt in that sense. And similar with climate change as well. It's like, yes, you can definitely situate yourself where you want in the 1.5 degree to 2 degree goal in terms of the national domestic emissions. But you can't situate yourself in a place that would mean that the world is heading towards 3 degrees or 2.5 degrees or something. There's just certain things that are just off the table. And those aren't off the table just because the court says so, but because you've made fundamental commitments to human rights. And those entail certain limitations on your ability to just make up whatever law it is that you want to make up. And if you're not willing to accept those limits, then I think you need to take the political hit, so to speak, and disavow them and not pretend like you're fulfilling their obligations and you're fulfilling their demands.
And Will, if I can ask one more before handing to you, and perhaps I can see there's already one question in the Q&A. The question of the trade-off and competing interests is something that you speak to in the book. And I think one of the ways that you're sort of avoiding the need for too much of that is by making, once again, reverting to this minimum and saying, let's make the demands of the environment in this particular context, not overall, sort of as small as possible. So we're not demanding more and therefore having more potential encroachment on other worthy objectives. But even, down at that size, there will be occasions where the human rights that are environment associated will potentially conflict with human rights associated with other things like economic development. Could you speak to how that gets resolved in your framework?
Yeah, so you're going to have these conflicts. I think it's unavoidable. And I think it's baked into the very notion of human rights, at least the notion broadly pan-European notion that I subscribe to. So not everyone likes this perspective on human rights, but the view of human rights that I have is that essentially I followed Joseph Raz. It's an interest-based theory of rights. So essentially I'm saying what we're saying when you have a right to something is that you have a very strong constitutionally or internationally or regionally recognized interest to something. That is never an absolute trump. That never means that, or very rarely only will that ever be an absolute trump. So that always means that there is someone's countervailing interests or rights that are being impacted whenever it is that we give priority to your rights. And that's fine in principle. I think courts wrestle with this kind of stuff all the time. How do you determine what is unjust dismissal? Like, courts need to specify that and have specified that through a series of very complicated case law. And in the same way, courts need to balance these considerations against each other. There's nothing particularly challenging for the legal system. I think in some ways that's probably the easy part for the legal system to kind of adjust to. There's other stuff in the book that I'm suggesting that will be more complicated. But you can see that tension. And you can see that tension also with the Sustainable Development Goals, I think, quite neatly. There are some excellent goals in the Sustainable Development Goals. I don't want to come across as a hater or something, but there is also, and this is the problem, there's absolutely no guidance and no way to balance these things against each other. You have a Sustainable Development Goal of close to full employment, and you have a Sustainable Development Goal or various Sustainable Development Goals that speak to environmental protection. Economic development and energy security are not easily compatible with environmental protection. I think we need to be very blunt about that. Any sort of human economic development entails environmental harm. Full stop. There's no such thing as a no environmental harm human development. And that being the case, I would really like to know a bit more, and this is what the framework tries to do, about how much environmental harm are we allowed to, or should we take on the chin in order to achieve outcome of, I don't know, poverty eradication. And that's not an easy question at all. You can find people on both ends of the spectrum that argue very strongly for one or the other. But I think it is quite rich, especially for the richer, more developed countries, the 1% of the world, if you will. And I think it's safe to say we live in the 1% of the world in that sense, for us to say, well, you really need to take better care of your environment. But at the same time, that just means that we keep getting to fly across vast distances across the globe and jet setting and doing whatever we want, and you guys need to live on a carbon budget that is the equivalent of me driving my car down the road. So that's ridiculous, obviously. So I think it needs to, because it is a global problem, it requires a global effort. And I think because that is the case, the language of human rights is actually quite helpful, because it allows us to balance these seemingly unbalanceable interests against each other. That doesn't mean we're always going to get the balance right. Courts make mistakes, as do legislatures and as do others. But I think that's one of the ways forward, and it's better than positing absolute rights and principles that we can, in practice, not ever treat as an absolute.
Thanks so much, Stefan. Will, I'll let you have a turn. Thanks.
Thank you.
Well, thanks, Emma, and thanks, Stefan. Fascinating exchange. I'll open to Q&A now, and I'll go immediately to a question which has been asked in the Q&A box. And I'll read the question out. Why define a minimum for the environment when there are so many things we seek to maximize? GDP, employment, consumption. Why not seek to maximize environmental outcomes? Now, I assume this question is one of the drivers of it is, active versus negative institutional behavior vis-a-vis the judiciary. So, Stefan, over to you. Maybe I'm wrong.
Yeah, no, I think part of it obviously is semantics, right? So on the one hand, we can maximize the environmental protection in light of all other challenges, or we can ensure that an environmental minimum is realized despite everything that's going on. So I think on some level, I want to almost just say that's mostly semantics. On the other level, I think there's a deeper point here about my view for specifically the judiciary in this case. Obviously, this book, I think, has something very interesting to say to regulators as well, and to people who aspire or are environmental activists. But I think one of the big audiences for this is obviously the judiciary. And I think especially in a common law system, I think the judiciary is, in its relationship with legislative and executive branches, much more comfortable in seeing itself as the backstop to certain regulatory and legislative efforts, as opposed to seeing itself being at the forefront. So I think just as a pitch, if I were to tell a Australian or a British judge they should go out there and seek to maximize a certain good that I agree, and I'm sure a lot of people would agree, it should be protected, I think that is a much more uncomfortable position for them to put themselves in institutionally and conceptually than it is to say, no, what you're really just doing is you're enforcing the logical consequences of certain fundamental commitments that the state has already taken on, that the legislature or that the constitutional lawgiver or whoever has already committed the state to. Right? You're not doing anything extravagant here. The only thing you're really doing, and I mean this genuinely. This is not just window dressing. The commitment that has been made to human rights entails certain environmental protections that are currently not being met in the vast majority of states, the vast majority of the time. I think full stop. And that is there's absolutely nothing activist from my perspective in saying, you've made this commitment, now you need to live up to it. If you don't like the commitment anymore, then by all means get rid of your Bill of Rights or leave an international protection regime that you've joined, but don't try to have your cake and eat it too. Don't pretend like you're living up to the commitments while you're actively not actually doing anything towards their meaningful fulfillment. So I think that in some ways is an easier pitch to make to a judge, but also I think is a much more clear and a much more, I think, honest assessment of where we are.
Emma, feel free to jump in, of course, if you have something to add.
I've got one more thing, but go for it, Will. I've had plenty.
No, I was going to move on to a new topic, so please jump in.
So, well, mine was related to the other, which you already speak to in the book. Coming from the environmentalist perspective, potential critique, and that is the anthropocentrism, which I think I managed to pronounce. And you do, you speak to this in the book, I think, quite effectively. But my question is, the logical framework that you're proposing, could it not equally be applied if a state has brought on and just, decided to give, I don't know, a mountain or a certain species certain basic rights and acknowledge those rights? Could your framework not equally be applied to those? It doesn't need to be restricted to human rights.
No, not at all. I mean, it definitely could work. I didn't mean to come across too cynical about those. So this has happened, I think, in certain South American countries. I think it's also happened in New Zealand, if I'm not mistaken. I think there's legal personhood was extended to certain mountains and rivers. I'm not 100% sure on that. I don't want to be too negative about those. That's if that is part of an overall push to recognize and emphasize the status and the importance of environmental protection within that jurisdiction, then by all means do it. But I think, and this is where I get a bit critical of these kind of initiatives, it is not an end to itself. So granting the legal personhood to a mountain, designating, as I think Ecuador has done, Mother Nature within the Constitution as someone worthy of protection and of particular regard, is not the end point of the kind of efforts, the kind of legal efforts that I think need to be made. It's at best, it's the starting point. What really changes something on the ground is changing some of these fundamental, and often they are private law rules about how businesses conduct themselves, how businesses can operate, when to grant planning permission for certain polluting industries, when liability is extended to certain industries for their conduct. So there's a German energy conglomerate that is currently being sued by a Peruvian farmer because, this is the allegation anyway, the emissions emitted into the atmosphere by that energy conglomerate over decades has over time raised the temperature in their particular region of Peru, which is leading to the melting of a glacier, which threatens their farmland. If you're making a change as a state with respect to those liability rules, saying that we don't need but-for causality anymore, we're satisfied with something less than, can you prove that but for the industry emitting the emissions over those decades, the glacier would not have melted? No, of course not. No one can. But is it perhaps sufficient that the industry contributed to a measurable degree to global warming as such? And is that something that they need to then also be liable for in proportion to their overall emission? Then yeah, I think that's, if you actually introduce a change like that, then I think that tells me that you're serious about the environmental harm, and that you're serious about actually affecting a change through law. If you're granting legal personhood to a river or writing Mother Nature into your constitution, that can be part of that, but that is not a substitute for it. Indeed, I would say if you're prioritizing that over real important changes that industries will fight tooth and nail to resist in practice, if you're not doing something like that, if industry isn't resisting your legislative change, then I think you might want to think about whether it's actually doing something.
Look, thank you both. I think we've waded into fascinating territory, which is sort of quite realist and involves, locates the court, but the judiciary anyway, in a very complex global sort of political economy. I can't help but think about, from a kind of broad constitutional perspective, the famous exhortation of Professor Bickel that courts are the least dangerous branch of government. That they're actually the least effective, they're the least potent, they're the most conservative, and we shouldn't put any of our major social problems in their hands, because with some exceptions which have been very prominently wound back recently, particularly in the United States in constitutional contexts, you can't rely on the courts to be a vanguard against sustained social coalitions, implicitly or explicitly in favor of a particular type of harm allocation. And of course, the Norwegian Constitutional Court's Greenpeace decision, the Federal Court of Australia's Sharma decision, both examples of what you, Stefan, were talking about in terms of kind of the microstructure of environmental and human rights litigation. There were questions about exploration, drilling permits, coal mines, that were framed in the context of the climate emergency and all of the, both legal standards and established standards that, you deal with. And so, this leads us, in my mind, back to polycentricity. You end up in this question of what mechanisms do the courts use to take themselves out of politically charged or economically kind of dominant or domineering disputes for their local sovereign, right? What do courts rely on to say, I'm not going to touch this? And I think there's such important work done in the book around Fuller, because Fuller articulated polycentricity in order to insulate economic policy from the judiciary. That's why it was built. And the only example he gives of a polycentric dispute is a dispute about national budget legislation. Really, I mean, and it's an attempt to say, look, these questions of kind of macroeconomic political distribution just can't be resolved by courts and shouldn't be resolved by courts. Of course, you do such positive work in saying, well, that's with respect to the deceased Professor Fuller nonsense, because that happens all the time. What motivates courts to step in or step out of the macro economy in meaningful senses, which is what both the Norwegian court and the Australian court chose to do, to step out of this conflict between capital and citizen groups. It's something else. It's not polycentricity. It's something else. So I suppose the question for both of the panelists, what drives courts really, if polycentricity is a red herring, what really drives them to be the weakest branch in this context where it really matters, in jurisdictions where it really matters? And is the environmental minimum the way to push them into the fray and to say, look, have courage, gentlemen and gentlewomen, in you go. It's yours now.
Yeah, I think I'll defer on the economics to Emma. I'll leave her to respond to that part. But I think a big part of what makes the courts, obviously there's institutional reasons, but I think particularly with environmental reasoning, what makes them weak in some ways, and I think this is not necessarily a bad thing, is a certain level of self-consciousness about having to justify their decisions with reasons that not only follow from what they've said previously, but also fit into a broader institutional understanding of where they are within the constitutional hierarchy of things, within the relationship to other branches, right? So there's a bit of a hesitancy in there, which is not necessarily a bad thing, because a court is quite rightly saying, well, it is not up to me as an individual judge to take decisions that require broad societal buy-in unless there is a strong reason, a strong prior commitment in law already. So that can be a constitutional commitment. I think those are the strongest ones, because there is at least conceptually, an argument in there to say, well, what I'm doing as a judge is not really inventing anything in the novel sense of the word, but I'm just holding us as a society accountable to commitments that we've already made to ourselves. Now, obviously, that gets tricky because we get into social contract theory and we get into this idea, well, who actually agreed to this at what point? I mean, I'm pretty sure that when I was born, and I'm also sure that when you guys were born, no one handed you a piece of paper to sign. Obviously, it's not that simple. But I think at least conceptually, that's easier for a judge to say, I'm holding us accountable to our prior commitments. And I think in some ways, that's what I'm trying to kind of like get into. That's the avenue I'm trying to exploit, and saying, yeah, we have this prior commitment to constitutional environmental protection and human rights, and you're just following through on that commitment in a very modest way. You're not telling the legislature or society what the objective is, but you're telling them that there are certain things that just can't stay the way they are, that need to change. How they change is up to someone else. And I'll pass over to Emma.
I'm just looking at the time. I think there's a much longer conversation that could be had about Fuller, but yeah, this is a broad problem. In the field that I work in international economic law, this sort of that economics has priority over other things like international environmental law. There's a long running debate. I think we're starting to see a shift that's been forced, unfortunately, by the fact that we're in existential crisis. But this is really a neoliberal philosophy that is definitely of debatable merit. Yeah, I'll leave it at that.
Thanks, Emma. I mean, it might have made sense in the 1960s, as with all these things, when Professor Fuller first articulated his ideas of judicial restraint with the economy, but maybe it doesn't make so much sense today. There's one final question, which I would really like to put to both of you, and maybe for, and apologies for hurrying, but we are coming up on time, and it's from Professor Vivian Holmes from the ANU, who is interested in your view that there cannot be human development that doesn't cause environmental degradation. What about things like regenerative agriculture that improves food, etc., outputs while improving degraded environments? What about soil quality, which leads to other improvements? So I might just, and apologies for rushing, including to Professor Holmes, but maybe 1 minute each, and then we should finish just a bit over time.
No, that's great. I'll keep it short. Definitely, there are certain things that humans do that can be in the grand scheme of things environmentally neutral. That's completely fine. That's completely understandable. But any sort of development that the modern societies that we currently live in require, and that is everything from the beautiful building that you can see in the background of Emma's video screen there, or airports, or the computers that we're currently using to communicate. those things degrade. And I don't mean this necessarily in a negative way, because resources are also, to an extent at least, there to be used. Degrade resources that are naturally occurring and require harm to the environment. I think we just need to bite the bullet on that. If we're going to have computers, airplanes, and buildings, then we're going to have some level of environmental harm and degradation, and that, in some level, that's fine. And in the future, we might be able to figure a way out of avoiding all of that. I don't want to preempt that, but I think that's currently the world that we live in.
Yeah, I guess that I agree with Vivian. There are triple bottom line win things that we can do. Another one that springs to mind is agrivoltaics, where in many cases you actually improve the agricultural productivity of the land by adding some solar panels. So there are these wins, and regenerative agriculture is another example. Perhaps the point is that perhaps there's always some winners and losers, and even those solar panels came from somewhere, and their production almost surely was associated with environmental degradation. On the other side, I think that it's important to challenge the concept of what human development means, and this gets back to the whole SDG goals. Is us having more laptops or more energy to keep our homes that bit warmer really the way we should be measuring human development? But that's another very big question.
Well, thank you so much to Stefan and Emma, and to our audience for joining us tonight.